when they come into court and they have to support and defend their opinions under oath and cross-examination, those opinions, they just melt away. There simply wasn't any evidence. There weren't any empirical studies. It's made up. It's junk science. And it's easy to say that on television, but the witness stand is a lonely place to lie. And when you come into court, you can't do that. And that's what we did. We put fear and prejudice on trial.
Thank you, Mr. Cooper. Mr. Olson, why don't we just begin at that point that Mr. Cooper just left off with? And that is, in a sense, isn't the danger not that you're going to lose this case either here or at the Court of Appeals or at the Supreme Court, but that you might win it?
Well, I think the case you're referring to has to do with abortion, Your Honor.
It does indeed.
Your Honor, the cases upon which we rely have been entirely different cases. They have relied on fundamental, established constitutional law, because the argument that Mr. Cooper makes is essentially the same argument that was made to the Loving Court, which, by the way, the Loving Court unanimously decided to strike down. And we stand here today thinking, how could that have been? In 1967, that's only 40 years or so ago, we would have punished as a felon in the state of Virginia the president's own mother and father if they had tried to travel there and be married. Now, Mr. Cooper's argument is, and I know why he would like to take back these words, we don't know. We don't have to prove anything. We don't have any evidence. Yet, he was reading from articles written by various persons who did not come into this courtroom and testify under oath, and who did not subject themselves to cross-examination by my colleague, Mr. Boyes. Some of them didn't come into court because they had been cross-examined by Mr. Boyes in their depositions. But you do have to know. He does have to prove. The Romer Court specifically says, under the lowest standard of review, you have to prove that you have a legitimate interest and that the subject, Proposition 8 in this case, advances that legitimate interest. So how does preventing same-sex couples from getting married advance the interest of procreation? What one single bit of evidence is there that they are a threat to the channeling function? If you accept that California has the right in the first place, and I do not, I believe, Your Honor, that there is a political tide turning. I think that people's eyes are being opened finally. People are becoming more understanding and tolerant. The polls tell us that. There isn't any secret in that. But that does not justify a judge in a court to say, I really need the polls to be just a few inches higher. I need someone to go out and take the temperature of the American public before I can break this barrier and break down this discrimination. Because if they change it here in the next election in California, we still have Utah, we still have Missouri, and we still have Montana. This case is going to go to a court. Some judge is going to have to decide what we've asked you to decide. And you have to have a reason, Your Honor, and you have to have a reason that's real, not speculation, not built on stereotypes, and not hypothetical. That's what the Supreme Court decision tells us. And I submit, at the end of the day, I don't know, and I don't have to put on any evidence. With all due respect to Mr. Cooper, does not cut it. It does not cut it when you're taking away the constitutional rights, basic human rights and human dignity from a large group of individuals. You cannot say after the fact, we are going to take away the constitutional right to liberty, privacy, association, and sexual intimacy that we already tell you you have. That is not acceptable. It is not acceptable under our Constitution, and Mr. Blankenhorn is absolutely right. The day we end that, we will be more American. Thank you.